In this lecture, we are going to talk about the general applicability of privacy and cybersecurity laws to artificial intelligence systems. Remember again, 10 miles wide, 1 inch deep. You don't need to know the specifics of most of these laws. We will talk in the next lecture about the GDPR, and there are some specifics there that you should be concerned with. But in general, the most important thing is that you're familiar with the fair information practices, which we dealt with in a previous domain, and you understand the challenges that AI poses to complying with some privacy laws. As we've mentioned, many privacy laws will apply to AI's data, and remember, AI is all about the data. If your system is going to be operating in the European Union, it will be subject to the General Data Protection Regulation, or GDPR. We'll talk about that in the next lecture. In the United States, at the time being, you need to be concerned with the California Consumer Privacy Act, or CCPA. The reason I say for the time being is because there is legislation currently under consideration in Congress that may preempt the CCPA, but when and if that happens, I will update these lectures. Another state-level law that you need to be concerned with is Illinois' BIPA, or the Biometric Information Privacy Act. You and your team also need to make sure that the system is properly secured. Cybersecurity laws will apply. For example, if there's a data breach, you'll need to consider breach notification laws, both under cybersecurity and privacy statutes. And for certain certifications, you'll also want to make sure that you comply with the use of cybersecurity standards and you're able to pass audits and so forth. Challenges concerning privacy and cybersecurity law. We've talked about a lot of these already. With regards to notice and consent, for example, this is really difficult when you're using commercially available information or you're using data sets that were scraped from the web. The vast majority, if not all of that data, if it contains any PII, the data subjects whose PII it belongs to certainly were not provided notice that their data ended up in a commercially available data set, and those individuals almost certainly did not consent to having their data included in that data set as well. As such, there are problems with secondary use, purpose specification, use limitation, access and amendment, and right to deletion. Similarly, these data subjects are not going to have the rights they should under codes like the Fair Information Practices. Again, those include access, amendment, and the ability to delete data that's been used to train a model. It is very difficult, if not impossible or unfeasible, to remove data that is in a model once that model has been trained. Another adjacent issue concerns laws targeting automated decision-making. In some cases, those laws may not deal explicitly with artificial intelligence, and if they do, they may not be dealing with AI in depth. So again, remember, one of the stakeholder groups that you're going to incorporate into your AI governance body is going to be your legal team. And it's important that your legal team is aware of the issues concerning privacy and cybersecurity. In this lecture, we looked at a very high level at the standards that AI systems will be held to concerning privacy and cybersecurity law, a number of challenges that will represent themselves throughout the AI development lifecycle are notice and consent and data subject rights, and keep an eye on laws targeting ADM. They may or may not have sufficiently dealt with AI in depth and will need to be analyzed by your legal team.